Hello, my name is Helen Higginbotham and I'm a Legal Director at Harrison Clark Rickabees and a Qualified Chartered Company Secretary. Today I'm going to be talking about company secretarial considerations during the Covid-19 pandemic. It is important during this time for directors to make strategic and policy decisions to protect the interests of their stakeholders. Clearly, effective decision-making is key during this time. It is possible for directors to hold virtual board meetings, whether that be by teleconference or video link, as long as each of the directors can hear and participate in the meeting. ICSA, the Chartered Governance Institute, has issued some guidance regarding virtual board meetings, such as providing a timed agenda, timed presentations, and ensuring that there is sufficient time for the board to ask questions. It is clear that the chairman during this time is a valuable asset. When speaking to my company secretarial colleagues, it seems that actually this new virtual board meeting norm actually allows for more efficient, regular and concise meetings. Just remember that the chairman can sign the board minutes electronically following the meeting and can circulate it to the rest of the board. The alternative to board meetings is for the directors to sign a director's written resolution. Each of the directors will need to sign the resolution for it to be validly passed. And of course, this means that the directors would not be able to engage in an active discussion at the time the resolution is passed. A few things to mention during this time. Number one, strike-off applications. Companies House will publish the notice in the Gazette, but then they will suspend taking any further action. Number two, buybacks of shares. Form SH03. You can send the unstamped form with a letter from HMRC that the correct stamp duty has been paid. Thirdly, unfortunately, there is no same-day filing service available during this time. And finally, on a positive note, you can apply to extend the deadline to file your accounts if it appears that you are unable to meet the deadline due to COVID-19. You need to make sure that you submit the application before the deadline for filing your accounts, and you may not be eligible if you have already changed your accounting reference date. If successful, Companies House will grant an extension of up to 3 months. The general rule is that private limited companies are no longer required to hold annual general meetings unless their articles of association require them to do so. The current government guidelines state that gatherings of 2 or more persons are prohibited unless it is deemed essential for a work purpose. It is therefore questionable whether attending a general meeting would meet this criteria. The company therefore has 4 options available to it. Number 1, to delay calling the general meeting. Number 2, to postpone the general meeting. This option is only available if the company's articles of association allow for this. Number 3, adjourn the meeting. But remember that it may be necessary for a quorate general meeting to be held to actually adjourn that meeting. And finally, the meeting can proceed to be held, but note that the shareholders need to be informed that they may be unable to attend in person and instead encouraged to appoint proxies. It is worthy of note that the chairman can refuse entry to shareholders to protect the health of the shareholders as a whole. If the notice of general meeting has already been issued, the solution here is to seek to adjourn the meeting by convening the meeting at its original location or just outside, and adjourning the meeting to another location. ICSA, the Chartered Governance Institute, has recommended that the announcement of an intention to adjourn the meeting should be published on the company's website so that it is clear that that's what the intention is. It is possible for a company to hold a hybrid meeting where you have a quorum physically present and then additional members dial in. You can do this provided your Articles of Association allow this. All can hear and participate in the meeting, and everyone is given clear guidance as to how this will work, and of course the company has the infrastructure to put that in place. The other alternative for shareholders to pass and reach decisions is by way of written resolutions. And I thought I'd take a moment now to talk about how that can happen for private limited companies in an electronic format. Firstly, the company can send resolutions and communications to shareholders by email, provided that the company is given express consent to do so and an email address for that purpose. The company can receive electronic documents from its shareholders, providing the identity of the shareholder is confirmed and the company has no reason to doubt its authenticity. Finally, the company itself must consent to receiving documents in electronic format, either expressly or it's deemed to have provided consent if, for example, an email is provided in the notes to the resolutions. Thank you for listening. If you have any queries, please don't hesitate to contact me and stay safe.